Good morning, everyone. First of all, I would like to thank Ageless Legal for giving me a platform like this where I can speak on any topic I like and present my views on the same. So the topic I chose for today is rights confined to women under the constitutional law. Now, as you all know, women are the weaker and the vulnerable section of the society. There are certain group of human beings which either because of their nature or because of the deep-rooted customs are weakly and vulnerably treated in society. Women, aged person, child, disabled persons, they all are a victim of the same. But especially women are deprived of their rights. This is because women are not aware of the rights they are conferred to. They are not aware of the privileges they can have. It becomes very easy for the male to dominate women because women do not know of their rights. But as they all are human beings, they do possess some fundamental freedoms and rights. So now I am going to tell you regarding that. To start off, I would like to quote what Sarah Moore Grimke in her book Letters on the Equality of Sexes and Condition of Women has stated. All history attests that man has subjugated woman to his will, used her as a means to promote his self-gratification, to minister to his sensual pleasures, to be instrumental in promoting his comfort, but never has he desired to elevate her to that rank. He has done all that he could debase and enslave her mind, and now he looks triumphantly on the ruin he has wrought and says, "The being he has thus deeply injured in his inferior. But I ask no favors for my sex. All I ask for our brethren is that they will take their feet off from our necks and permit us to stand upright on the ground which God has designed for us to occupy." Now, I hope you all can understand what she meant by that. She meant that woman has been deprived of their rights. They have been dominated by the male from the very beginning of this world. So, there are few rights which are confined to women, and that has to be accessed by the woman only. The principle of gender equality has been enshrined in the Constitution of India in its preamble, fundamental rights, the directive principles of state policy, and also the fundamental duties. The state not only grants equality of women but also empowers measures against the discrimination of women. Many plans and programs are constituted to secure equality of women. The state aims at advancement of women in all spheres. The advancement of women has been a focus of the work of United Nations since its creation. The General Assembly on 7 November 1967 adopted a declaration on the elimination of discrimination against women, and in order to implement the principle set forth a declaration called CEDAW, which is a convention on the elimination of all forms of discrimination against women, which was adopted by the General Assembly on 18 December 1979. The first article of CEDAW says, "The term discrimination against women means any distinction, exclusion or restriction made on the basis of sex which has the effect or the purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of their marital status, on a basis of equality of men and women, and of human rights and fundamental freedoms in the political, social, cultural and any other field." Swami Vivekananda once said, "The best thermometer to the progress of a nation is the treatment of the woman. There is no chance for the welfare of the nation unless the condition of the woman is improved." So, the preamble to the Indian Constitution resolved to secure to all its citizens justice, social, economic and political, liberty of thought, expression and belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and the integrity of nation. To attain these objectives, the Constitution guarantees certain fundamental rights and freedoms, such as freedom of speech and expression, such as protection of life and personal liberty. Indian women are beneficiaries of these rights in the same manner as men. Article 14, 15 and 16 ensure equality and prohibit discrimination on the basis of sex. The directive principles of state policy, though are non-justiciable, are considered by the state in formulating policies and laws. Some of the directives are providing free and compulsory education and providing adequate means of livelihood for men and women, equal pay for equal work and other maternity reliefs. In short, fundamental rights and directive principles provide the framework to achieve the ideals of the preamble. Fundamental duties to recognize upholding the dignity of woman as one of the duties. So, the preamble incorporates certain rights and privileges to women so that women are not deprived with their rights. They are treated equally at par with men in all fields and all sections of the society. Human rights, which are the entitlement of every man, woman and child because they are human beings, have been made enforceable as constitutional rights and fundamental rights in India. The constitution framers were conscious of the discrimination meted out to the fairer sex from time immemorial, and therefore they have set forth certain general principles and specific provisions for the upliftment of the status of women. Justice Bhagwati in Maneka Gandhi versus Union of India, AIR 1978 stated, "These fundamental rights represent the basic values cherished by the people of this country since the Vedic age, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent." Few articles are enshrined under the Constitution of India so that the women are not deprived of their rights and they are given their privileges. The first is Article 14, that is equality before law. Article 14 declares that the state shall not deny to any person equality before law or equal protection of law under the territory of India. Equal protection of law is a mere positive concept which implies equality of treatment in equal circumstances. It does not mean absolute equality among individuals, which is not physically possible to achieve. It is a concept of implying absence of any special privileges by reason of any sex, caste, creed, race or likelihood of any individual, and equal subject of all the individuals and classes to the ordinary law of the land. Dr. Jennings said that equality before law means that among equals the law should be equal and treated alike. The right to sue and be sued, the right to prosecute and be prosecuted for the same kind of actions should be same for all citizens of full age and understanding without distinctions of race, religion, wealth, social status or political influence. Article 14 embodies that the general principle of equality before law and prohibits unreasonable discrimination between persons. Article 14 is an epitome of the noble ideals expressed in the preamble of the Constitution. Now, I would like to quote what V.R. Krishna Iyer and P.N. Singhal has stated in the case of C.V. Muthamma versus Union of India, AIR 1979. In this case, the petitioner, who was a senior member of the Indian Foreign Service, had brought a petition against the government on the grounds that she has been overlooked her promotion to grade 1 because she was a woman, and also because the service rules of the employment of women in the civil service are discriminatory in nature and therefore contrary to Article 14 and 16 of the Constitution of India. The court held that this writ petition filed by Miss Muthamma, a senior member of Indian Foreign Service, bespeaks a story which makes one wonder whether Article 14 and 16 is a myth or a relief. The credibility of constitutional mandates shall not be shaken by any governmental action or inaction, but it is the effect of the grievances of Miss Muthamma that sex prejudice against Indian womanhood pervades the service rules even a third of a century after freedom. There is some basis for the charge of bias in the rules, and this makes the ominous indifference of the executive to bring about the banishment of discrimination in the heritage of service rules. If high officials lose hopes of equal justice under the rules, the legal lot of the little Indian, already priced out of the expensive judicial market, is best left to guess. Commenting further on the discriminatory rules, the court said that discrimination against women in traumatic transparency is found in this rule. If a woman member shall obtain the permission of the government before she conducts marriage, the same risk is run by the government if a male member contracts a marriage. If the family and domestic commitments of a woman member of the service are likely to come in the way of the efficient discharge of the duties, a similar situation may well arise in the case of a male member. In these days of nuclear families, intercontinental marriages, and unconventional behavior, one fails to understand the naked belts and against the gentler of the species. In the case of Air India versus Nargis Mirza, 1981, the Supreme Court struck down the Air India regulations relating to retirement and pregnancy bar on the services of air hostesses as unconstitutional on the ground that the conditions laid down therein were entirely unreasonable and arbitrary. The impunged Regulation 46 provided that an air hostess would retire from service of the corporation upon attaining the age of 35 years or on marriage if it took place within 4 years of service or on first pregnancy, whichever occurred earlier. Under Regulation 7, the managing director was vested with the absolute discretion to extend the age of retirement up to 45 years from the early retirement of 35 years. Both these regulations were struck down as violative of Article 14, which prohibits unreasonableness and arbitrariness. So, the next is Article 15, which is prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. Article 15 declares that the state shall not discriminate any citizen on grounds of religion, race, caste, sex, or place of birth, or any of them. This means that no citizen can discriminate any other citizen on grounds of religion, race, caste, sex, or place of birth and subject them to any disability or liability or restriction and condition them with regard to access to any shopping malls or public places like restaurants, hotels, multiplex, movie halls, theatres, or any other places, and use of any wells, tanks, hospitals, bathing huts, roads, or any public place which is wholly or partly owned by the state and dedicated for public use. Nothing in this article shall prevent the state from making any special provision for women and children, and for making any special provision for the advancement of any socially or educationally backward classes or citizen, or for the scheduled caste or scheduled tribes. Thus, Article 15 prohibits gender discrimination. Now, I would raise my point with a case law. The constitutionality of Section 497 of IPC was challenged before the Supreme Court in the case of Soumitra Vishnu versus Union of India, 1985. Here, the petitioner challenged the validity of the section on the ground that it violated gender equality. It was contended on her behalf that the section of adultery punished the man who had illicit relations with another person's wife, but did not punish the woman who was a party of adultery. The section enabled the husband to prosecute the paramour of his wife, but did not allow a wife to prosecute the woman who had an adulterous relationship with her husband, and therefore violated Article 15(2) of the Constitution, which prohibit discrimination on the grounds of sex. The discrimination was between an adulterer and an adulteress because while the former could be prosecuted, the latter could not be prosecuted. Further, there was a discrimination between a married woman and an unmarried woman, or a widow or a divorcee, because a man's illicit relation with a married girl or a woman constituted the offence. His illicit relations with another woman did not constitute the offence. Similar was the case of Veeravati versus Union of India, AIR 1988. The next is Article 16, that is equality of opportunity in matters of public employment. Article 16 of the Constitution provides that equality of opportunities for all and prohibits discrimination against women. Article 16 subsection 1 states that there shall be equal opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 16 subsection 2 states that no citizen shall, on the grounds of religion, race, caste, sex, or place of birth, or descent, or residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. These two clauses of Article 16 state that no citizen shall be discriminated against any opportunity. The Constitution thus provides equal opportunities for women implicitly as they are applicable to all persons irrespective of sex. However, the courts realize that these articles reflect only de jure equality to women. They have not been able to accelerate de facto equality to the extent of the Constitution indeed. Reflecting this in Dimple Singla versus Union of India 2002. The Delhi High Court expressed its apprehension that unless attitude change, elimination of discrimination against women cannot be achieved. There is still a considerable gap between the constitutional rights and their application in the day-to-day lives of most women. At the same time, it is true that women are working in jobs which are hitherto exclusively masculine domains. But there are still instances which exhibit lack of confidence in the capability and efficiency. There remains a long and lingering suspicion regarding these capacities to meet the challenges of the job assigned. Such doubts affect the dignity of a working woman. And also a famous landmark case is the Air India versus Narges Mirza, which I have explained earlier. So the next article is Article 21, which is protection of life and personal liberty. Article 21 of the Constitution of India says that no person shall be deprived of his life and personal liberty except according to the procedure established by law. It means that every citizen has the right to live with dignity, be it men or women. It protects the right to life and personal liberty not only from the executive action but also from the legislative action. The right to life and personal liberty of every citizen cannot be deprived only if two conditions are fulfilled. That is, 1. There must be a law, and secondly, there must be a procedure established by law, provided the procedure is fair, just and reasonable. So I raise my views with a landmark case which happened in the year 1996. The case is Bodhisattva Gautam versus Ms. Shubhra Chakraborty. The facts of the case were that the accused not only induced the complainant and cohabited with her, giving her a false assurance of marriage, but also fraudulently got certain marriage ceremony performed knowing fully that the marriage was void. The accused even committed the offense of miscarriage by compelling the complainant to undergo abortion twice against her free will. The way the accused exploited the complainant and abandoned her is nothing but an act of grave cruelty, as same as which caused serious injury and danger to the complainant's health, both physically and mentally, such that the accused, above mentioned name, has committed criminal offences punishable under Section 312 for causing miscarriage, Section 420 for cheating, Section 493 for cohabiting, Section 496 for conducting marriage ceremony fraudulently without lawful marriage, Section 498A, which is domestic violence. Now, the Supreme Court, refusing to quash the prosecution, ruled that rape was not only an offence under the IPC but was also a violation of women's right to live with dignity and personal freedom. The court further added, it is a crime against basic human rights and is violative of the victim's most cherished of the fundamental rights, namely the right to life contained in Article 21. To many feminists and psychiatrists, rape is a sexual offense than an act of aggression aimed at degrading the humiliating woman. Now, the next article is Article 23, which is Prohibition of Traffic in Human Beings and Forced Labor. This article prevents right against exploitation. Article 23 of the Constitution specifically prohibits traffic in human beings. Trafficking in human beings has been prevalent in India for a long time in the form of prostitution and selling and purchasing of human beings, especially women. This includes the Devdasi system which prevailed in Andhra Pradesh. To give meaning to Article 23, various laws have been passed to prevent exploitation of human beings, that is, the Immoral Traffic Prevention Act 1956 and Andhra Pradesh Devdasi's Prohibition of Dedication Act 1988 are legislations which prohibit the practice of prostitution and dedication of Devdasis respectively. In the famous case of God of Jain versus Union of India AIR 1997, the Supreme Court issued directions for the prevention of induction of women in varied forms of prostitution. It is said that women should be viewed more as victims of adverse socio-economic circumstances than offenders in our society. So these were the fundamental rights. Now, there are certain rights which are conferred to women under the directive principles of state policy. There is a basic difference between fundamental rights and directive principles of state policy. The fundamental rights cater to individual needs and the directive principles of state policy cater to social needs. The fundamental rights are justiciable rights and directive principles of state policy are non-justiciable rights. It means that if fundamental rights are violated, any citizen can move to the court. But if the directive principles of state policy are violated, a citizen cannot move to the court. This is contained in Part 4 of the Constitution. Though these principles are not enforceable in law, but they are fundamental in the governance of the country and provide for the welfare of the people, including women. One such right is Article 39, which provides certain principles of policy to be followed by the state for securing economic justice. Article 39A directs the state to direct its policies towards securing that citizens, men and women equally have the right to adequate means to livelihood. Article 39D directs the state to secure equal pay for equal work for both men and women. The state, in furtherance of this directive, passed the Equal Remuneration Act 1976 to give effect to this provision. Article 39E specifically directs the state not to abuse the health and strength of workers, both men and women. So the next is Article 42, which is provision for just and human conditions of work and maternity relief. Article 42 of the Constitution incorporates a very important provision for the benefit of women. It directs the state to make provision for securing just and human conditions of work and for maternity relief. This upholds a claim of non-regularized female workers for maternity relief. The court stated in the case of Municipal Corporation of Delhi versus Female Workers Master Rolls AIR 2000 that even workers on casual basis and daily wages of municipal corporation are equally entitled to maternity benefit. The state has implemented this directive by incorporating health provisions in the Factories Act 1948, Maternity Benefit Act 1961 and the Bidi and Cigar Workers Conditions of Employment Act 1966, etc. Now the next is Article 44. So let me read out what Article 44 claims. Article 44 directs the state to secure for its citizen a uniform civil code applicable throughout the territory of India. Its particular goal is towards the achievement of gender justice. Even though the state has not yet made any efforts to introduce Article 44 in India, the judiciary has recognized the necessity of uniformity in the application of civil laws relating to marriage, divorce, maintenance, succession, etc. But as it is only a directive, it cannot be enforced in a court of law. The issue of uniform civil code has been controversial right from the very beginning. The Constituent Assembly debates clearly by bringing out the fact that there was a lot of opposition to incorporating Article 44, particularly from the members of the Muslim community in the Assembly. However, one of the most dynamic members of the Assembly, Sri K. M. Munshi, expressed his opinion that If the personal law of inheritance, divorce, succession, etc. is considered a part of religion, then the equality of women can never be achieved. After initial hesitation, the judiciary has taken note of the injustice done to women in personal matters. The court has been voicing its concern through a few judgments, indicating the urgency to have uniform civil code in personal laws. One such important case in which the court voiced its concern is Muhammad Ahmed Khan versus Shah Banu Begum, AIR 1985. Pertaining to the liability of a Muslim husband to maintain his divorced wife beyond the period of iddat if the wife is not able to maintain herself. The Supreme Court, through Justice Chandrachud, held that Section 125 of CRPC, which imposes such obligation on all husbands, is secular in character and is applicable to all religions. It applies to all Indians generally and overrides the personal law if there is a conflict between the law. The obiter in the historic judgment rocked the Muslim community, leading to the enactment of Muslim Women Protection of Rights on Divorce Act 1986. Lastly, Article 51AE, which is a fundamental duty. Article 51AE states that it shall be the duty of every citizen to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices of derogatory to the dignity of woman. Now, this is not the end. There are few other constitutional mandates like Article 243 D3. Not less than one-third, including the number of seats reserved for scheduled castes and scheduled tribes women, of the total number of seats to be filled by direct election in every panchayat to be reserved for women, and such seats to be allotted by rotation to different constituencies in a panchayat. Article 243 D4. Not less than one-third of the total number of offices of chairpersons in the panchayats at each level to be reserved for women. Article 243 T3. Not less than one-third, including the number of seats reserved for women belonging to the scheduled caste and scheduled tribes, of the total number of seats to be filled by direct election in every municipality to be reserved for women, and such seats allotted by rotation to different constituencies in a municipality. Article 243 T4. Reservation of offices of chairpersons in municipalities for the scheduled castes and the scheduled tribes and the women in such a manner as the legislature of a state may be by law as provided. Women enjoy a unique position in every society and every country of the world. Despite their contribution in every spheres of life, they are subjected to disadvantages. Because of the barriers they face, they suffer silently. This is because the men dominate women in the all possible ways that is there. Women need to raise their voice against this. Unfortunately, we live in a country where women, when made of mud, are treated as goddess. They are worshipped as Shakti. But when the same women are made of blood, they are not given the equal respect and the position which she deserves. India, being a paradox, is no exception. Let me give you an example of the same. Suppose a man or a boy who grows up seeing that his father beats up his mother every day. The mother suffers silently. So, from this, the boy can take up two lessons. One is very obvious, that is, he can also grow up and beat his wife every day. And the second is, by seeing the suffering his mother has, he can grow up to be a good man and treat his wife like a queen and don't beat her any day. Similarly, this depends on the mentality of the person who treats the woman. We can never change it until and unless men understands the sufferings of women. Men understands the position which women should be given and that women are also equal to men. So, by this I conclude my views on the status of women and the rights confined to them. Thank you, Ageless Legal, for allowing me to speak on what I wanted to. Thank you.